Hi, I'm Ben Schwartz, and today we're going to do a video about the truth, the whole truth, and nothing but the truth. You know, if you've been watching my videos, you know that I am a jury trial lawyer. It's what I do for a living. It's what I've been doing for almost 20 years at this point. And when we swear in a witness at trial, we ask them to swear or affirm that they're going to tell the truth, the whole truth, and nothing but the truth. And there's something about jury trial work that has been bothering me for a long time. And so I'm just going to put it out there. If you're an attorney or if you're a judge, I'd be interested to know. If you're a member of the general public too, I'd be interested to know what your thoughts are on this topic. But we ask jurors who are giving evidence, who are giving testimony in our jury trial cases, our personal injury cases, our criminal defense cases, and other trials, to tell the truth, the whole truth, and nothing but the truth. But when it comes to the information that we give to the jurors, when I say we, I mean the court, the judge, the trial lawyers involved in the case. When it comes to the information that we're giving to the jurors, to make a decision in the case, we're not giving them the truth, the whole truth, and nothing but the truth, because the evidence rules don't allow us to do that. And I'm going to give you some examples, and I want you to think this through. And what I'd like to know is, are we looking at things wrong? Do we not trust the jury to come to the right result if they have all the information? Let me give you some examples. Let's say that we have a criminal case, and let's say that a gentleman is at a restaurant. He's had too much to drink. Let's say he's driving down the road and he's weaving, in and out of his lane. The police pull him over and he's got glassy eyes, reeks of alcohol. Clearly he's intoxicated. The police ask him to consent to a breathalyzer test and he refuses to consent, and so they get a warrant to draw his blood. And they use a blood test kit that's expired. This is an actual case that occurred in the state of Delaware. And one of the attorneys in my law firm went to trial with it. They used an expired, what's called a vacutainer. And because it was expired, the test was not valid. Now let's say that that case goes to trial with a jury. The judge is going to exclude the evidence of the blood test that shows that the person was over the legal limit, because the test was expired and it's not legally, evidentiary, from an evidentiary standpoint, it's not a valid test and it's not reliable enough to go to the jury. But it is evidence. I mean, it could go to the jury and the jury could figure out if they think it's valid or not valid, but that doesn't go to the jury. And so maybe in this particular situation, the jury does not have a key piece of evidence that they need in order to determine guilt or innocence. I'll give you another example. Let's say that a defendant in a criminal case has a long criminal history, and they've got many arrests, many convictions over the years. Now they get arrested again, and they're brought to trial to answer for the crime that they've been charged with. That long criminal history isn't going to make it to the jury. The jury's never going to hear about it. They're not going to hear about the prior drug dealing charge. They're not going to hear about the prior child abuse charge. They're not going to hear about any of that stuff, even though this individual was convicted on all of those cases. The reason is because we have an evidence rule, 404B. Rule 404B says that the prior bad acts, the prior crimes, are not admissible in order to prove that that defendant has a character from which you could infer action and conformity therewith. And so those prior convictions are not going to be coming into evidence. We're not giving the jury all of the information. We're editing out the information and giving them some of it. We're giving them what we deem to be relevant, what we deem not to be overly unfairly prejudicial. Here's another example. Let's say that someone's walking through an apartment complex, and there's an area where there's a damage to the walkway surface. It's been worn away over the years and no one's done anything to maintain it or to fix it. And as a result of the defect in the walkway surface, there's a defect in the sidewalk, the person trips and falls or slips and falls and they get very seriously injured. They break their hip, they almost died. They spent months in the hospital recuperating. Medical bills are $400,000 and they're traumatized for the rest of their life. Within days after the accident happening, the apartment complex went out and they fixed the surface. They patched it, they fixed it up, they made it nice and smooth. Now nobody else is going to fall. That's called a subsequent remedial measure. They went out and they fixed it. The fact that they went out and they fixed it is not admissible in the trial of that personal injury case to prove that there was something wrong with the sidewalk in the first place. Subsequent remedial measures are not generally admissible at trial for that purpose. Here's another example. Let's say there's a car accident case. Someone gets rear-ended. They're severely injured. They file a lawsuit for personal injuries against the at-fault driver who rear-ended them. The at-fault driver's got $1 million in insurance coverage. We're not going to tell the jury that there's any insurance coverage, much less the amount of the insurance coverage. So the jury has to make a decision on how much to award the injured plaintiff, sort of in a vacuum, not knowing what of that award is going to be collectible, or even if there's insurance in the first place out of which a verdict could be collected. These are all types of information that we withhold from jurors in personal injury cases, in criminal cases, and the reason that we withhold it is because we've got these evidence rules that sort of edit out the information that might not be perfectly reliable, that might not be completely relevant, or that might be unfairly prejudicial to one side or the other. But I want to ask you, you're watching this video, you might be an attorney, you might be a judge, you might be a member of the general public, not involved in the legal profession. You might be a paralegal. We get a lot of good comments and a lot of good messages from folks who are paralegals. Or you might be a law school student. We get a lot of good information from law students as well. But what do you think? Do you think that as attorneys and judges, do you think our paradigm, that our view is wrong and we should just trust jurors and give them everything so that they have all the information? Or do you think it's right to edit the information that goes to the jury? I'd be interested in having a conversation about this topic. I'd be interested to know what you think. I've felt this way for a long time, ever since I started trying cases, that we should just trust our juries. We should just trust them and give them all the information and give them the most credible information we can. But I'm interested to know what people think. Thanks for watching this episode. This has been another 10 with Ben episode. My name's Ben Schwartz. You can send me a message. I'm at mail@benschwartz.com if you want to send me an email, or complete a contact us form on this website and get a hold of us that way. If you're watching this video on YouTube or on social media, leave a comment wherever you are and tell us what you think. Thank you for watching.